Uniting America with truth, justice, and independence. This is the Norman Goldman Show.
So the Supreme Court today gutted the Voting Rights Act. They did not throw out the pre-clearance, right? They said pre-clearance stays. What they said, however, was that the formula Congress created to decide who's covered by this law is unconstitutional, and therefore Congress can now, nobody can, not the administration, not the Attorney General, no one can now enforce the Voting Rights Act because nobody now knows who's covered by the Voting Rights Act. To me, the heart of the Voting Rights Act is the pre-clearance, meaning Florida, Alabama, Georgia, right? These states that have a history of discriminating against minority voters, they still have to pre-clear their changes. The problem is we now have no way of knowing who's covered by the law because the Supreme Court said that the congressional designation of who's covered by the law is based on an unconstitutional formula, and so it's out. So we now have a Voting Rights Act that says you have to pre-clear your changes to all your voting procedures with us. You have to ask us permission first. You have to ask the Justice Department first before you implement these things, or you have to bypass that by going to a court and asking the court to give you permission to do this. The problem is who the you is now gone, and it's going to remain that way until Congress changes the formula. The Supreme Court today said that Congress was using outdated numbers, and therefore Congress has to come up with new numbers. All Congress now has to do is nothing, and the Voting Rights Act has been effectively repealed because it doesn't apply to anyone. Here's why I'm really upset at the Supreme Court. The Congress, before they reauthorized the Voting Rights Act in 2006, held 10 months of hearings. That encompassed more than 20 different hearings. Congress heard testimony from more than 50 expert witnesses, and Congress amassed a record of over 17,000 pages of documents showing the discrimination against minority voters in the South principally, but in other places as well, to justify the renewal of the Voting Rights Act. They didn't just rubber stamp it. And when they reauthorized it, they reauthorized the Voting Rights Act in 2006 by a vote of 390 to 33 in the House of Representatives and 98 to 0 in the United States Senate. Congress compiled a record. In fact, Shelby County, the plaintiff in this case, plaintiff is the one doing the suing, Shelby County, Alabama, went to the Supreme Court and said, throw this thing out as unconstitutional. Shelby County itself, according to Justice Sonia Sotomayor, 240 changes since the Voting Rights Act started, including recent ones in Shelby County, Alabama, blocked by the Voting Rights Act. So the very party that brought the lawsuit is itself guilty of trying to, hurt minority voting rights. Here's the problem. The Chief Justice of the United States, John Roberts, who wrote the 5-4 majority decision, today's decision, and I quote from the decision, "Nearly 50 years later, things have changed dramatically. And if you go through the decision, through the majority decision of the 5, what you see is a lot of statistical evidence being cited by the Supreme Court, by these 5 members of the bare majority, saying, look at all these statistics that we have showing how dramatically times have changed. Here's the problem. They are substituting their statistical assessment for the Congress. The last time I looked, the United States Supreme Court is unelected, unaccountable, appointed for life, and you cannot reduce their pay in office. The United States Supreme Court legislated from the bench today. The United States Supreme Court engaged in a blatant act of judicial activism because what they did was they acted like a super legislature. They said, our assessment of the evidence is better than Congress's assessment of the evidence. Our statistical compilation is better than Congress's statistical compilation. I invite you to go through the majority decision today from the 5, and you will see them citing statistic after statistic from the Census Bureau and even from the congressional record, those 17,000 pages I told you about a minute ago. They combed back through it and they rejudged the evidence. That is not the job of the United States Supreme Court. That is why this is judicial activism. This is legislating from the bench. There is no better case of it.
Uniting America with truth, justice, and independence. This is the Norman Goldman Show.